Welcome everyone. I am glad to see that everyone could take time to join me. Today, I would like to talk briefly with you about information system, privacy, security policies, code of conduct and HIPAA. Feel free to take notes if you wish. The purpose of this training is to align the organizational risk appetite with organizational activities. These policies are made to protect and serve our customers better and also to protect ourselves. It is expected that we all follow these policies on a daily basis. The information that resides on the company's infrastructure is very crucial for the company and for our customers. Due to the increasing volume of customers' data we process through our infrastructure, the company's responsibility to protect the information has grown exponentially. We are now forced to protect ourselves from service disruption, misuse, unauthorized access, and last but not least, any potential disclosure of customers' information. I would be glad to take any questions you have in the end. Let's get started. The following two slides outline what we will be covering here today, such as privacy principles, review of privacy standards, information system security, and so on and so forth. And then we will be moving on to other topics such as secure clean desk policy and integrity of products and so on and so forth. You get the idea. The company is responsible for safeguarding the privacy and personally identifiable information as required by legislative, regulatory, and contractual obligations. Failure to comply with this or any other security policies will result in corrective actions as per the disciplinary process policy. The company is also obligated to take the disciplinary actions such as written notice, suspension, removal of access rights, removal of duties, or termination of contract for violation of the security policies. Personally identifiable information includes information in any form such as first name, last name, phone number, address, ID number, income, ethnic origin, or blood type. So, what should be done about this? First and foremost, we ought to limit the amount and type of information gathered for identification purposes to what is absolutely necessary. Second, we ought to make sure we limit the use of personal information only for the purpose for which it was collected, unless we obtain prior consent from the individual to utilize the information for other purposes. Third, we should be responsible about how long we keep personal information and see to it that it is only kept as long as it is necessary to satisfy the necessary purposes. Lastly, the company is obligated to safeguard the information and from unauthorized access, disclosure, copying, misuse, modification, and or loss. The ISO 27002 policy, a document, has privacy policies created with some of the most common privacy laws in mind, and we need to follow them. There are more such policies in the market such as GDPR, CCPA, PIPEDA, CBPR, GLBA, Graham-Leach-Bailey Act, and PDPB. The General Data Protection Regulation, also known as GDPR, is a legal framework that sets guidelines for the collection and processing of personal information of individuals within the European Union. The CCPA, also known as California Consumer Privacy Act, Canada's Personal Information Protection and Electronic Documents Act, PIPEDA, is a privacy toolkit or guide for businesses and organizations. The CBPR, also known as Cross-Border Privacy Rules. The GLBA, otherwise known as Graham-Leach-Bailey Act, required the Federal Trade Commission, the FTC, and other government agencies that regulate financial institutions to implement regulations to carry out the Act's financial privacy provisions. The Graham-Leach-Bailey Act's notice and opt-out provisions are in addition to the obligations imposed by the Fair Credit Reporting Act, FCRA. The Office of the Privacy Commissioner of Canada has set 10 PIPEDA principles. India's Data and Privacy Bills is the Personal Data Protection Bill, also known as PDPB, which provides guidelines for users' personal data. More such guidelines are yet to come, hence we need to follow whatever we have today. A number of countries in which we operate in require us to be privacy compliant. It is the law. Moreover, it is essential to maintaining our reputation. Our clients trust us with their customers' data, and it is absolutely necessary we do everything to ensure that that data is protected. Furthermore, consequences for non-compliance include severe regulatory fines, loss of business, and potential exposure to lawsuits. How can you help? Review the privacy principles and the various standards as they apply to the company and ensure we implement whatever is required. Follow company processes outlined in sections on data handling as laid out in ISO 27002 Production Operation Procedures and the Employee Handbook. If you notice non-compliance in any area, let your manager know or let me know. GDPR. GDPR came out in 2018. It has 7 principles. Number 1, lawfulness, fairness, and transparency. Need informed consent from the data subject. Need documentation on when data was collected. Need reasons for processing data. Rule is exempted for public task and public interest. Number 2, Purpose limitation. No further processing beyond the originally specified purposes.